Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Kevin Estevez, an Arizona construction lien law expert. Today's webinar topic is how to get the bonding company to pay in Arizona. So without further ado, I'd like to introduce the fabulous Kevin Estevez.
Thank you, Jesse, and good morning or afternoon to everyone, depending on where you are. Like Jesse said, we're going to talk about bonds today, and we're going to talk about two specific types of bonds. We're going to talk about lien discharge bonds, and then payment bond claims on public projects. So with that, we'll jump right in. If you have any questions during the course of this presentation, please use the GoToWebinar chat box on the right side of your screen, and we'll save those up at the end, and we'll answer the questions at that time. Please do not include any company names or personal names in questions. Please have everything be generic, and we'll answer those when we're finished. Like I said at the outset, the scope of today's presentation is related to two types of bonds. First is lien discharge bonds, and the second is Miller Act payment bonds, and Little Miller Act payment bonds in Arizona specifically. There are all sorts of other types of bonds that arise on construction projects. You can have, especially in Arizona, you can have license bond claims. There are private project bond claims, but all of those are outside the scope of today's presentation. Given the time allotted, I want to just go over the two of the most common types of bond issues that subcontractors, contractors, and suppliers have to deal with. So as a theme to all of these webinars, one of the probably the most important thing you can do as a contractor, subcontractor, or material supplier in Arizona to protect your rights to get paid is issue a preliminary 20-day notice. As set forth here on the slide, except for laborers for wages, every lien claimant and some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice within 20 days of beginning work on the project to secure your right to payments. Now, as we've talked about before in these presentations, if you don't serve a 20-day notice at all, you forfeit your lien rights, and likely you forfeit, or you can't potentially, depending on your role on a project, forfeit bond rights. Not serving a timely 20-day notice, if you're in that bucket and you serve a 20-day notice late on a project, you're gonna likely waive some of your lien claim and or bond rights. So if you don't issue a 20-day notice at the outset of a project, you want to do it as soon as possible. And the way it works is if you do a 20-day notice late, it reaches back 20 days and covers the work going forward on the project. So if you do it within the first 20 days, it reaches back to the date work starts. If you do it after the first 20 days, there's going to be a period of time where you furnish labor and materials as either a contractor or supplier in a project where you're not covered. And that is a crucial issue on lien claims in Arizona. It's also a crucial issue on bond claims. And once you have a 20-day notice issued, it's not a set it and forget it. You have to monitor 20-day notices because if the amount of labor or material that you furnish to a project increases by more than 30%, 130% of the by 30% of the amount of the lien claim, the amount of materials set forth in the 20-day notice, then you have to supplement your 20-day notice. So it's something that you have to stay on top of, and you have to monitor throughout a project. So like I said, Arizona law gives you 130% of the value that you put in your preliminary 20-day notice. You get lien rights up to that amount. If the amount of labor and material goes beyond that, you have to supplement the notice. So whether it's lien claims, whether it's bond claims, it's imperative in Arizona to send out preliminary 20-day notices or have those sent out for you. First type of bond we're going to talk about today is lien discharge bonds. And these bonds are statutorily prescribed. And what happens is after a lien is recorded, a property owner, a contractor, subcontractor, mortgagee, or other lien creditor related to a project has the option of posting a statutory lien discharge bond. And the statute that governs these is Arizona Revised Statute 33-1004. There's certain requirements for these types of bonds. First, they must be recorded in the county where the project is located and served on the lien holder. They must be executed by the person seeking to discharge the lien, and an authorized surety. Must be for the sole protection of the lien claimant, meaning that they must say in there that the lien claimant is the obligee under the bond. And importantly, they must be in the amount equal to 150% of the demand in the lien. So if the lien sets forth a claim of $100,000, the discharge bond must be $150,000. And as someone who maybe has recorded a lien on a project and a discharge bond is subsequently issued, it's important that you don't automatically assume that the discharge bond is operative. It's something that needs to be fly-specced, and gone through very carefully, because I can't tell you how many times throughout the course of my career I've seen a discharge bond posted and there's been some sort of fundamental error in the bond. Either the amount's incorrect, the obligee is listed instead as a lien holder, it's listed as somebody else, and numerous times where I'm representing a client who has a claim against the bond, I've had to go back to the person posting the bond and or the surety and say, hey, you've got a problem with this. So you want to make sure that before you operate as if the lien discharge bond is effective, that it complies with all the statutory requirements. And so that's something that going to need to be done before you pivot down that road. If a lien discharge bond is recorded pursuant to the statute and it complies with the statute and it's operative, what that does is it discharges the lien on the property. And if a lawsuit is already pending, the lien claimant must amend his or her suit to add a claim on the bond. If a lawsuit is not yet pending, the claimant must file suit against the bond within 6 months of recording its notice and claim a lien. And if you recall from some of the presentations we've given about lien deadlines, that 6-month deadline is the deadline to sue to foreclose on a lien. So it's the same deadline. If one's posted, you have to sue on the bond within that amount of time. And if you don't, your lien claim and then your bond claim will go away. So that is discharge bonds in a nutshell. It's a bigger topic we could go into in more detail, but for purposes of today, that's a general overview of lien discharge bonds. So the main thing is make sure that once if a bond is posted, that you are going through and making sure it complies with the statute, and then provided that it does, you have to, if you're a lien claimant on a project, you have to alter your approach to pursue the bond rather than the lien. And in many respects, that makes a lawsuit a lot less complicated. A typical lien foreclosure lawsuit, if there's other lien claimants on there, you're bringing a lot of parties in because when you sue to foreclose a lien, you have to name everyone who has an interest in the property. So if there's other contractors or suppliers out there who haven't been paid, they need to be parties to the lawsuit. If a discharge bond is posted with respect to your lien, then your suit is against the party that posted the bond as the principal and the surety, and so the lawsuit becomes, in many respects, a lot simpler. The next type of bond we're going to talk about today is public project payment bonds. As I'm sure most folks are aware of, you can't lien public property, and so because public property can't be liened, federal and state law require payment bonds on projects of a certain type and size. And qualified subcontractors and material men may have claims against the bond if they satisfy certain notice requirements. So here we're talking about on federal projects, Miller Act payment bond claims, and on state projects, we're talking about Arizona Little Miller Act payment bond claims. So the Federal Miller Act protects those furnishing labor and materials to federal projects, and Arizona public payment bonds are governed by Arizona's Little Miller Act, and federal and state notice requirements differ depending upon contract tier, and we'll go through those right now. One thing that is similar under both the Miller Act and Arizona's Little Miller Act is who has claims against a bond that's furnished pursuant to the statute. You'll have in both instances, it's the general contractor who posts the bond, and this chart here that you're looking at shows who's protected. So under both Little Miller Act and Federal Miller Act payment bonds, first tier subcontractors are protected. And I mean, those are folks that have an agreement with the general contractor who posted the bond. First tier suppliers are protected. And then if you move down here on the left-hand side, second tier subcontractors, which are folks that have a relationship with a first tier subcontractor, and second tier suppliers, who are folks that have a relationship with a first tier subcontractor, are protected. As set forth here in the chart, in the red squares, third tier subcontractors are not protected, third tier suppliers are not protected, and then on the supplier side, second tier suppliers are not protected. So that gives you an overview of who's protected and who has claims on Miller Act and Arizona Little Miller Act payment bonds. Now, what do you have to do to preserve those claims? And this is where we get into a difference between state and federal law. Under the Federal Miller Act, folks with no direct contractual relationship to the general contractor furnishing the bond. So this is either, if we go back to the previous slide, this is either the second tier subcontractor here on the left-hand side, or the second tier supplier to a subcontractor. Those folks are required to give written notice to the contractor furnishing the bond within 90 days of the date on which the person did or performed the last of the labor or furnished or supplied the last of materials for which the claim is made. So once as a contractor or supplier, once you on a federal project, once you issue your last, once you perform the last work or issue or furnish the last materials to a project, it starts a 90-day window within, and if you haven't been paid, as you're getting closer to that 90 days, you have to furnish a written notice to the written 90-day post-completion notice saying, hey, I'm out here, I haven't been paid. Arizona is a little bit different. If you are a claimant who has a direct contractual relationship with the subcontractor of the contractor furnishing the payment bond, but not a contractual relationship with the contractor, you have to issue the 90-day post-completion notice like you do under the Federal Miller Act. But there's a pre-notice, which is the preliminary 20-day notice that we talked about at the outset of this project or this presentation. So you have to issue a preliminary 20-day notice like you would when you're asserting or preserving a lien claim on a project. You have to do it at the outset. It has to comply with the ARS 33-992-01 notice requirements related to liens, and then you have to give a 90-day post-completion notice. And so that's, again, once it's the last day that you furnish labor or materials to a project, within 90 days of that date, if you haven't been paid, you got to let the party furnishing the bond know that, hey, I'm out here, I haven't been paid, and we're preserving our claim for payment. So under Arizona law, you have 2 notice requirements, where under federal law, you have 1. And then deadlines. So once you issue your 90-day post-completion notice, you have under both federal and state law, you have to bring suit within a year of when you last furnished labor or materials to a project, but you can't bring suit within that 90 days. So if you think about it, you have 90 days that expire where you have to give your notice of non-payment to preserve your bond claim, if you're a party that has to give notice, and you can't sue to recover on the payment bond within that 90 days. But once that 90 days lapses, then you have essentially 270 days, because you're still measuring the time to sue within a year of when you last furnished labor and materials to the project. So those are the important deadlines on both federal and state Miller Act and Little Miller Act payment bond claims. You can't sue within 90 days of when you last furnished labor and material. Lawsuit's not ripe yet, but then provided that you provide that notice, then you have a year within which to sue from the date you last furnished labor and materials. And one of the things we've covered before, and something that trips people up, is the deadline on this as it relates to payment bonds versus lien claims. Lien claims in Arizona, you have your deadlines are all measured from completion of the project and the last day that anyone furnished labor and materials to the project. Payment bond claims under both the Miller Act and the Arizona Little Miller Act are measured differently. They're measured from the date that you last furnished labor or materials. So the potential to have time to act on a lien claim is potentially much longer than the time to act on a bond claim. And that is the end of today's presentation. As always, a quick disclaimer here. Case law and statutes relating to construction law in Arizona are very detailed, with a lot of technical requirements and exceptions. This presentation cannot substitute for legal advice. If you have a question on payment bonds, if you have a question on lien discharge bonds, please consult with a qualified attorney. And with that, I'll turn it back over to Jesse and see if we have any questions.
Well, first of all, thank you so much, Kevin. You were really fantastic, and it was very informative, so I appreciate that. Yes, we do have a question that came through. I think it's something that you kind of just went through, but we'll ask it anyhow for you. If I'm a sub working for the bonded GC, can you have bond claim rights if you did not send the 20-day preliminary notice?
So if you're a sub working for the GC and it's a state project and not a federal project, yes. So in Arizona, if you are a sub that has a direct contract with a party that furnishes the bond, the notice requirements don't apply. It's when you're a step removed, and the idea is consistent with the purpose of a 20-day notice. Generally on private projects or public projects, it's to let folks know that you're out there performing work on the project, to let folks know who wouldn't otherwise know. And so if you have a direct contract with the party that furnished the bond, they presumably know you're out there performing work on the project and expect to be paid. So those notice requirements don't apply. Still, okay. It's a good practice to issue a 20-day notice anyways.
Right. All right. Thank you so much for that. And then another question came through. If I'm a sub but the subcontractor that I'm contracted with has a subcontractor's bond, and there's also a general contractor's bond. Can I put a claim on both bonds?
Yes, and the requirements may be different, and that's something that you're going to have to look into. In that circumstance, if it's a public project, the general contractor's bond is likely going to be dictated by the either federal Miller Act or Arizona's Little Miller Act. The subcontractor's bond may be structured differently. So you may have a claim on both bonds, but you're going to want to look very closely at the subcontractor's bond if it is essentially a private bond that's not governed by the terms of the statutes.
Okay, wonderful. Thank you so much. That seems to be all the questions that have come through. If anyone does think of another question that hasn't been addressed, please feel free to reach out and we'll be sure to answer questions for you. Can you go to the next slide for me, Kevin?
Sure.
All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead, scan that QR code to access these incredible resources. And then the next slide, if you don't mind. All right, so if you don't mind, take a moment to review us on Google. We really appreciate it. Any of your feedback is wonderful. It helps us improve, get certain topics out to you guys, and it also helps just get the other content to contractors and suppliers like yourselves. So we really do appreciate it. And then the next slide. All right, and with that, that is all we have for you guys today. Thank you so much to everyone who attended. Kevin, again, you are incredible. We hope to see everyone at our next webinar. Thanks so much. I hope you all have a wonderful and sunny day, and happy holidays.